Hi, this is Steve Carlson. I've announced as a 2016 independent candidate for President of the United States from Minnesota. And I've been the nominee for the Minnesota Independence Party for the U.S. Senate against Al Franken and Mike McFadden. And this is a second video on the action at the Minnesota Supreme Court on free and fair elections. And I'm briefly sharing some of my positions in this series too. And I've talked about creating jobs along the Mexican border, and I want to disclose a couple more of my positions, including religious liberties, protecting the rights of families to raise their children to be moral according to their conscience, and to marry in the traditional way. And that also has a jobs component in it, too, as we see today. In Oregon, there is strong evidence that men marrying men and women marrying women are colluding with their state government. And the state is teaching them how to go out and find Christian businesses and put them out of business. Usually the anti-discrimination agencies are helping the businesses, teaching them how to avoid lawsuits. But in Oregon, they're entrapping good people who just want to follow their conscience and their God. I support using the religious freedom legislation and the Constitution to protect rights of conscience and rights to be secure in your property and not have it confiscated by those whose religion is inimical to your religious beliefs. Secondly, on climate change. Of course, we all want to protect our environment. We live in it, and we don't want pollution. But further, we're experiencing significant drought, and we have large swaths of land in the Southwest, California, and along the Mexican border and much of the rest of the country, who are experiencing water shortages. And we know this will be an increasing problem in the future. And so rather than argue about what caused it, I want to respond to it by initiating successful water infrastructure development in all the states. But this would not be another federal program. It needs to be carried out in all the states. And under my plan, the power and resources would be returned to the states, instead of collecting money and power in Washington, a cadre of far-off elites in Washington, as Reagan said. And I'll address more later, but we can no longer tolerate the burgeoning federal debt and deficit. Now this climate development and water development and infrastructure will create millions of jobs, but also drive development in the 50 states, which is the key to America's competitiveness. Not government jobs, but private initiative and opportunity. So we're going to develop our opportunity by responding to the problems that we face in the states based on the climate, and develop new ways to prosperity and to continue the America as we know it and want to know it and want to give opportunity to all Americans. And I want to strengthen and protect civil rights and human rights. And I have positions on many issues I've developed since I first became the nominee for Congress in 2010. I'm a radical centrist and a problem solver, and I think voters want someone like that in any presidential race. But as I said in the first video, in Minnesota today and throughout the nation, the two national parties, the Democrats of the Obamas and the Clintons and the Republicans of the Bushes, have conspired to trample on the rights of independent voters. And you don't hear a lot about that from the Republican candidates. The numbers are growing every day, and we need to hear their voices too. Or from the Democrat candidates, and I believe there's 4 now. They're promoting their own national parties to get an edge in 2016. And one of my resources for this series is this used book, The Other Candidate, from 1983, inspired by John B. Anderson's campaign. And it cites John R. Rarick, the American Independent Party candidate, saying, "The major parties don't offer any real choices. Politicians today come on like they're being sold as a jar or jam or Campbell's soup, a jar of jam or Campbell's soup. At least we attempted to force them to deal with the issues." And that's what we need to do. But in order to do that, we need to address this judicial gridlock. Yes, there's judicial gridlock between the duopoly parties, and what they're locking out is independent thinking, independent voices, independent parties, and they're violating the rights of independent voters to associate, which is given to us under the First Amendment. So there are a huge number of independent voters in Minnesota and the nation. And this election litigation, which I am bringing myself pro se, I'm not a lawyer, is to restore those rights. I'm fighting for voting rights, which are being denied in Minnesota based on gender, based on race, and the state of Minnesota, during a time the Democrats controlled Minnesota state politics, have passed a law to abridge and deny participation in voting based on sex, based on race, and based on suspect classifications, in clear violation of the United States Constitution. And in litigating to achieve free and fair elections, I'm building on a successful U.S. Supreme Court case from the 1980s called Anderson versus Calabrese. The case is about independent voters and their parties. But since Anderson was decided, it's been Democrats and Republicans who have seized upon that decision and declared that it is to protect their rights of association, when the case talks about the need to protect independent voters. And now the Republican Chief Justice Lori Gildea of the Minnesota Supreme Court, who was appointed by Tim Pawlenty, has issued a train of baseless orders claiming the court and Minnesota courts have no responsibilities they must undertake to regulate the federal elections in Minnesota for either the U.S. House of Representatives, that's Betty McCollum, or the U.S. Senate, where the professional entertainer Al Franken, the famed authority on and author of Rush Limbaugh is a big, fat, stupid idiot, and other greats, is now representing this kind of political Wild West in Washington in the Senate. And naturally, the Republicans here don't like Al. They're embarrassed, but they're not motivated to regulate the Senate elections so they're free and fair. Instead, they're excited. And Sarah Janicek and Chief Justice Lori Gildea are two of the GOP partisans in Minnesota who are excited to be rid of the Independence Party of Minnesota, who they buried in a show election in 2014. And I'm challenging this action by Gildea and the Republicans on the court. Now, I'm grateful to someone who appears to be a male law professor or some high-powered attorney with the Twitter handle George Newman, who bombarded me with graceful critiques on the first part of this video and pointed out to me that 4 of the current justices are appointed by Pawlenty, and that is true. They are Republicans. I appreciate this observation. Also, all the Democrats on the court seem to be recusing themselves. And even though David Lillyhaug, who's one of them, himself represented Franken in his election contests and election petitions against Senator Norm Coleman of the GOP. And this is just as I'm doing now, pro se. So George, thank you, and let me show you more of the proof I promised you of voting rights violations by Democrats in Minnesota and their other serious material and deliberate violation of provisions of Minnesota election law and irregularities in the conduct of the 2014 election between myself and Al Franken. And yes, there was a Republican I've never met, Mike McFadden, who I understand is off making money again now. Well, they're all making money. And so I'm going to continue on here, and this is, now I'm going to get into the order that I'm challenging. And this is actually from reading from a brief which I've filed with the Minnesota Supreme Court. And I say, the order gives a false account of the petition itself, where I filed an election petition under Minnesota Statutes 204B.44. And it's a false account of the applicable laws and of the issues. It completely excludes a single mention of 204C.40. That's the tolling provision, which should have held up the issuing of Al Franken's certificate on December 19th, because there was a contest going on, and the law doesn't allow that. But Governor Mark Dayton, Mark Ritchie, Lori Swanson, they found a workaround so that they don't have to follow the law and Constitution. And so that really triggered this petition. And so, but the petition itself plainly sets forth the ground for a legal duty as the clear and unequivocal violation of 204C.40, the tolling provision. See Franken versus Palenti. That's a petition that was filed by Al Franken himself, in which this was cited, and he was told, no, it can't be released when you're in a contest. At that time, it was with Norm Coleman. Now, the order identifies and addresses the following grounds at pages 1 to 2. And this is Gildea citing this petition and characterizing it in her own way, which isn't quite right, but there's something there. Now, 1, participation in Minnesota precinct caucuses is unconstitutionally restricted by political party principles and by statute. See Minnesota Statutes 202A.16, 2014. Caucus participants are restricted to persons in agreement with the principles of the party as stated in the party's constitution, unquote, and who voted, are affiliated, or intend to vote with that party. And I say this misconceives the federal court resolution of this claim. First, the Minnesota statute in question, which requires those not in agreement to stay away from voting, is about voting, not just participation, although both are constitutional rights, participation being freedom of association and freedom of expression. Thus, it violates the 15th Amendment, denying and abridging the rights of men to vote because of their sex, the 19th Amendment, denying and abridging the rights of white men to vote because of their race and their sex, and the 14th Amendment, suspect classifications, equal protection of the law, and due process. And it violates Article 7, elective franchise of the Minnesota Constitution. Secondly, the issue decided by Judge Davis in that federal case was not the Minnesota statute, but the constitutionality of the DFL Constitution itself, without the state action element. Further, such a decision, while not binding on this court, is not grounds for res judicata in a time and election-specific petition or contest under Minnesota election law. It is just one decision on constitutional issues regarding elections. That's all. It doesn't bind me or limit me any more than it limits any other voter or candidate for the reasons discussed herein. 2, as the Independence Party candidate, and that should be nominee, won a statewide primary in the 2014 general election for United States Senator from Minnesota, he was unlawfully excluded from the debates between Senator Al Franken and candidate Mike McFadden. 3, the Minnesota Secretary of State has unlawfully refused Carlson's request to release email addresses provided by registered voters. This overlooks the additional fact, however, that these are by the Minnesota Government Data Practices Act public information, and that the record establishes that the practice for years had been to offer these for sale through the OSS Elections Office and Nancy Bream, one of the employees there. 4, Minnesota courts have impermissibly blocked the function of Minnesota Statutes 209.02 and 209.12, 2014, and have therefore refused to allow the scope and purpose of congressional election contests to be carried out. And this also includes barring the consideration of voting rights, freedom of expression and association, these are my comments, equal justice, and ballot access for independent voters, candidates, and parties to be enforced either in contests or petitions. It further overlooks the fact that no Minnesota court can sit as a judge of these issues I raised, and that Minnesota courts, when they do not allow the contest to proceed or refuse to allow the gathering and certification of evidence on the points raised, and when they knowingly allow the election certificate to be issued while an election contest is pending, and even omit these facts and claims from an order to dismiss, act as judges, which is impermissible under Morgan versus U.S. 801 Fed 2nd 445 from the D.C. Circuit in 1986, and Article 1, Section 5 of the United States Constitution. And 5, state officials, while opposing his challenges to election-related conduct, violated their duty of candor to the tribunal. Well, this misconceives the ground, which is not that they violate the law in the positions they take and advocate for, but they advocate for and they promote the violation of Minnesota election laws. And this is part of the equal justice claims. Now I'm going to look at the order's faulty legal analysis. Against this misstated and seemingly deliberate omission of the true grounds of this petition, the order applies the following thoroughly defective and legally baseless legal analysis. As set out at the top, the order completely overlooks and fails to consider the actual petition's trigger. It is true that had there been no partial order, which they did right away on December 18th, which didn't determine the contest at all. It was something Al asked for, and that Lori Gildea's office themselves had suggested that he do to undermine the contest. And the unlawful release of Al Franken's election certificate, December 19th, by Mark Dayton, Mark Ritchie, and Al Franken himself, the instant petition would not look like it does. This court, in this order, calmly contemplates the violation of Minnesota federal election law. And it's federal because it's established under the Constitution. The purpose of the petition is to allow the contest procedure to take place and to enforce Minnesota Statutes 204C.40 subdivisions 1 and 2. And this petition is a necessary second front of my legal assault on the stalling and blocking of these critical election fairness and constitutionality issues I have been forced to raise, so that they can never reach their true judges, that is to say, the U.S. House of Representatives for the McCollum contest, which the state officials and courts, including this Minnesota Supreme Court, refused to allow to proceed in 2012, or the U.S. Senate. Federal election law in Minnesota needs to be clarified, and clarified not in a way that fits the preferences and biases of any Minnesota judge or justice, but which comports with the United States Constitution. Now, when I use the term federal election law in Minnesota, I mean Minnesota election law for federal elections. And that's a separate statute, which is called Congressional Office, and it's 209.12 of the Minnesota Code. And it also needs to comport with the decisions taken and prescribed by others, not you, the Minnesota Supreme Court, not Minnesota judges and justices and lawyers, not by the Minnesota Supreme Court. So it does not matter in this field what we have declined, speaking of the Minnesota Supreme Court, or we have never, referring to some Minnesota Supreme Court decision and applying that to a federal election contest. And where it is well settled that you have no power as judges, that is to say, an election contest. On the contrary, you have a present duty to ensure that the petition and contest laws operate to ensure the, quote, procedure and safeguards which experience shows are necessary in order to enforce the fundamental right involved, unquote, are enforced through Minnesota Statutes 204B.44 and 209.12 and 204C.40, subdivision 1 and 2. And that's quoting from Smiley versus Home, the U.S. Supreme Court case. You and I are not all judges, and we are not all congressional candidates. You are the judges, and I am the candidate. However, you and I have one thing in common, which we are all called upon to respect. We are all Americans. We are constituted as Americans by the United States Constitution. That founding document does not give you any authority to take the actions you are taking. None. Petitioner brings this petition for rehearing on the order of dismissal of my 204B.44 election petition filed on or before April 20th, 2015. Determined to be dismissed in an opinion by Chief Justice Lori S. Gildea on May 20th, 2015, the order of dismissal or order, on the grounds that the challenged order completely ignores the grounds for the petition. Essentially, the order is a formal pre-briefing analysis. No briefs have been filed by the respondents to this petition, setting out two simple purported justifications for this misstatement of the true grounds and descriptions set out in the Minnesota Statute 204B.44 petition. First, Gildea argues that petitioner has also received finality on the first three grounds as she states them. Again, ignoring the plain fact that the contest at the three-judge panel was voidable because before the panel disposed of the contest, the governor, the secretary of state, and Al Franken colluded and conspired to illegally issue an election certificate, quote unquote, to Franken in clear violation of Minnesota Statutes 204C.40 subdivision 2. The order as an analysis of the petition is thus fatally flawed. Also noteworthy is the complete omission of any reference to Article 1, Section 4 of the United States Constitution, enshrining the federal right to vote and giving to Minnesota legislature and U.S. Constitution broad authority to prescribe code of elections in the state for selection of federal congressional membership. Article 1, Section 5, United States Constitution. Minnesota Statutes 204C.40 subdivision 2, which, by the way, was specifically cited by Governor Dayton's certificate issued to the U.S. Senate on Al Franken's behalf, December 19, 2014, with Secretary Ritchie's official state seal. The First Amendment, U.S. Constitution, freedom of political expression, freedom of political association, access to the courts to petition for redress to grievances. The 14th Amendment, U.S. Constitution. The 15th Amendment, U.S. Constitution. The 19th Amendment, U.S. Constitution. And Article 7 of the Minnesota Constitution, elective franchise. It also completely omits any reference whatsoever to governing federal court cases from the U.S. Supreme Court or the U.S. Courts of Appeals, which clarify what the duties of this court, as well as the other respondents to this petition, are in Minnesota for carrying out an election for Congress. This court simply may not decide an election petition, and there is an election contest implicated in this petition as well, while refusing to account for and recognize any federal law or constitutional provision or any federal controlling judicial precedent. Petitioner will add in these omitted federal authorities as I show the pattern of oversight's failure to consider misapplication and misconception of controlling statutes, decisions and principles of law, material facts, material questions in the case. And I'm citing Minnesota Rules of Appellate Procedure, Rule 140.01, which is the grounds in the procedure for petitions for rehearing at the Supreme Court and the Minnesota Court of Appeals. Actually, I think that's only allowed at the Minnesota Supreme Court. Now, the challenged order dismissing the petition clings to a stunted, judge-made version of the vigorous, robust democracy which our nation requires. The nation's democracy does not require going to law school or being elected or appointed by a partisan governor as the arbiter of federal elections. It requires a robust debate among candidates and voters to select the state's federal representative in the U.S. Senate. It does not require what Al Franken, professional, entertainer, and communications industry heavy, can get away with, or what the National Republican Party and its agents on a state court will allow. Here's an illustration. A hypothetical time, place, and manner is provided. Those are the words used by the Constitution, which were cited by Chief Justice Jerome Hughes in the 1932 case to Minnesota called Smiley versus Home. And I want to illustrate what a truncated and unconstitutionally narrow circumscription Chief Justice Gildea and her Minnesota Supreme Court have given to the jurisdiction and duty of the court under 204B.44. Now, Article 1, Section 4, that's the one interpreted by Smiley versus Home, of the Constitution as interpreted by U.S. Supreme Court in Smiley versus Home, provides not only a broad grant of authority, but it's also a mandate for the states that whatever they do in the prescription of election laws is going to determine and prescribe the election law. And I say this includes debates. And the point I'm making is that if it's prescribed, it's got to be followed. And it includes debates. Now, suppose there is a state of the United States at some time in its history, and its legislature determines to prescribe the time, place, and manner of selecting members of Congress. And it creates an elections commission. The Election Commission says all the candidates of whatever party will show up at the state fairgrounds, and anybody who wants to can go down there. People can make stories, write stories in the press about them, and they're going to debate the issues. The Elections Commission is going to set up all the questions, and after the end of the debate, you're going to have 3 days to go home, and then you can all go to your friends. And the polls are going to be taken at a separate time from the state elections. And you can talk with the other citizens and then vote. Everybody who brings their ID is going to be able to vote for the senator. Do you want Stephen Douglas or do you want Abraham Lincoln to be senator from Illinois? That is a time, place, and manner, and it would be prescribed by the legislature. And if you didn't have that debate, once that law was written, and they say, no, you can't be in the debate, then the state's going to have to enforce that. So there's no way they're going to exclude Abraham Lincoln just because they don't like Abraham Lincoln, so they want to exclude him from the Senate debate. But our system of democracy just can't allow that and survive. This example is prescribed by the legislature that this is the time, place, and manner by which the election is going to take place. As Smiley says, there's a whole range of things experience has shown to be needed to carry out an election. It's the same kind of language used by Chief Justice Knudsen in Odegaard versus Olson, and it's touched on by Sari versus Gleason. Now, these are both Minnesota Supreme Court cases talking about the validity or invalidity of elections, and that's what I'm asking here. This timeless vision of valid elections as the basis for office. So, to start with the argument. The argument of Gildea as the author of the court's opinion is a hardly veiled and unsupported accusation that basically petitioner is just dissatisfied with the outcomes forced on this federal election contest over the course of 2 elections, with a third one coming up, President 2016. That I'm dissatisfied with the outcomes of his previous election petitions and contests, is what's said at page 4 or 5. But this idea fails to consider that the Minnesota courts are not empowered to judge federal election contests. But having blithely characterized my claims as simple disagreement, she once again brings out the catch-all phrase for ignoring every asserted violation of the federal and state election laws and constitutions as, we have declined to use the remedies set forth in Minnesota Statutes 204B.44 to address any and all disputes concerning official conduct that relates to an election. And here I will show that the court that it must hew to the letter of the law, the plain text and procedures set out in the law, and not your own selected precedents and dicta. I will show how Coleman versus Ritchie and Minnesota majority, even Carlson versus Ritchie 2013, cannot and do not allow this court to withhold its jurisdiction and duty given by Article 1, Section 4, and by the Minnesota Congressional Election Code, including the petition provision, and that the contest provision and the tolling provision inter alia. Those cases can and must be distinguished from this case, and I will not re-argue each of them. But there is nothing material in those cases that can be used to stop this court's duty and jurisdiction to pull the certificate, allow the contest proceed, and adjudicate the grounds in the petition as they really are presented. At the outset, a petition must refer to an election. And so something that happened in 2012, or a law that was passed in 2000, a constitution that has been violated for years or decades, these cannot bar the bringing of a petition related to a 2014 election or a 2016 election under 204B.44. These previous cases, including the 2013 Carlson case, cannot decide the 2014 petitions, nor can they prevent the decision by this court, because this petition refers to the 2014 and the 2016 election. I'm running for president in 2016, and I assert the right to participate in a 2016 Minnesota Independence Party primary, because that is required by the invalidity of the 2014 Franken election, which resulted directly in my getting less than 5%, in carrying the party forward into the 2016 election as a Minnesota major political party. because the aim of the Republicans and Democrats was to eliminate the party by preventing this 5% threshold from being reached. And because these practices, wrongful practices, and conduct by individuals charged with a duty concerning the 2014 election caused the invalidity of the 2014 election and its results, including my vote total, which was unconstitutionally suppressed by these practices, which imposed an unequal, unjustifiable burden. And see Anderson versus Celebrezze, 460 U.S. 780 from 1983, info. And this was unequal, unjustifiable burden on my campaign and on my voters and my party, the Minnesota Independence Party. Secondly, you have no authority to depart from the procedures established by the election law, by the legislature and governor, in not vetoing it. Now, these were not established just this year. They have been modified over the years. Now, those procedural requirements are clear in 204B.44, which reads, upon receipt of the petition, the court shall immediately set a time for a hearing on the matter and order the officer, board, or individual charged with the error, omission, or wrongful act to correct the error or wrongful act, or perform the duty, or show cause for not doing so. So, among those would be Governor Mark Dayton, Mark Ritchie, or now Steve Simon, his successor, and Al Franken, and they would take his election certificate back from him, and they would order a court to proceed on the contest until such time as it should be forwarded to the United States Senate and United States House of Representatives. And it says, the court shall issue its findings and a final order for appropriate relief as soon as possible after the hearing. Failure to obey the order is contempt of court. Now, as you listen to what this court has done and what they propose to do here, it has nothing to do with what the law says. Okay, so you are to, 1, hold a hearing. You've never held a hearing. Then 2, order either correction or showing cause. There's never been a correction. The respondents have never shown cause because you have never allowed, or I should say required it. And 3, you need to issue your findings in a final order for appropriate relief. You've never done this because you've never done the hearing. In addition, now to usurping the power of Congress to hear these points I've raised in a congressional election contest, in which they're the sole judges, because they happen to me, and to make the elections invalid, in violation of the Constitution, of Minnesota laws, including the election code. In addition to this, now you are refusing the instruction caused by the framers and prescribed by the Minnesota legislature under that broad grant of authority. That means written in advance of the election, and that means that during the election, we are not all supposed to hang with bated breath on how you think the election should be decided. This is especially important for small parties, for independent voters. We need you to do your job. I realize the 2 big parties who you represent do not want you to sway the election one way or the other, and that this is part of your reluctance to intervene, quote unquote, by deciding these petitions. Perhaps this is even the doctrine of judicial prudence, careful to preserve your powers without political interference. And so you try to avoid them. But as I have argued and will argue here, under the Anderson standard, that is just not good enough for independent voters. It is not good enough for third-party candidates or the Independence Party as a certified major political party under the election code. It is not good enough because under Anderson there is the recognition that just treating the big national parties equally with the third party, and by the way, you should also determine these petitions for the 2 big national parties, but they seem to have reached some kind of a deal here. But this does not mean that the third party and the big 2 will be equally impacted. That case established the right of association under the First Amendment that cannot be unjustifiably burdened even by a measure that is applied to all parties. In Anderson, it was a third-party candidate who pulled 6% everywhere he went, just as I did, until this election where they knocked me out of the debates and did nothing but slander me in the press. So people, except for my previous 2 elections, people were really not able to find out who I was. And John Anderson could not get his petition filed to get on the Ohio ballot by the time the Ohio Democrats and Republicans had nominated their presidential candidates. Fair treatment, said the big parties. We did it. Why can't the independent party? The Anderson court said, but it falls unequally on the voters of the third party who have the same associational rights under the federal Constitution as you do. Now, in this case, the controversy first arose, my case, in 2012. There have been three main election issues at that time, which have been voting rights, ballot access rights, and equal justice. And the voting rights include the First Amendment. And all the points I have raised and the grounds and present duties I have set forth in my contests and petitions go to these three issue areas, which, if they're lumped under the First Amendment, that's correct. Except I could add, and I do throughout this, that there's equal justice for independent voters. We have to have the justice that is equal, not just the equal procedure, even if that procedure is not lawfully followed, whether it's lawful or unlawful, whether they follow the law or not. Treating us the same as the big two is just not good enough. Now, they're not just the Minnesota statutes. Note that Article 1, Section 4 also gives the same broad grant of authority to Congress to, by law, passing laws, as it does to you, the Minnesota Supreme Court, and the legislature, and you dishonor that, disregard that. Also note that under Ex parte Yarborough and other cases, the very right to vote in a federal election is enshrined in that little paragraph. You simply must honor this, and all these issue areas must be addressed. So the elections are fair, so the elections are free. And so independent voters will know we have the same right to associate politically through a party and through supporting a candidate or being a candidate, unburdened by unjustifiable practices, that those in the organized parties with all the money and media support, because they pay that money to those media, have. So the way you're supposed to have proceeded on this described supra is described supra, and you have never done this. And the precedents you set up in Coleman and Minnesota majority cannot and do not alter this. And you are and always have been violating the duties committed to you under the Constitution and election laws. So to the argument that my grounds, called 4 and 5 by the order, are predicated on disagreement with previous contests and petitions to begin with, no, it is not. Not disagreement or satisfaction with outcomes. I have repeatedly, and to no avail, reminded the justices here, as well as your panel in the contest in 2014, that you are not judges in this contest. See Morgan versus United States, 801 Fed 2nd, 445 from the D.C. Circuit, 1986. Opinion read by the circuit judge at that time, Antonin Scalia. So it follows there could be no outcomes rendered by you. What you have done in 2 subsequent federal elections with compounded effect is to prevent any outcome in the contest because you wanted to keep these issues, all of which are committed to and greatly concern each house of the U.S. Congress, from those houses and from their lawful authority. And as such, you have usurped their power, which is committed to them by the framers and the people. And so you have usurped willingly and systematically their power and authority and the people's power and authority. You have asserted unwarranted jurisdiction over congressional election contests in clear violation of 209-12 congressional elections. Now, petitions, fine. It appears that according to the CCEC, which is the complete Congressional Elections Code, you are given jurisdiction in petitions, but they're different than your powers and authority in state matters, even state office elections, like the governor or your own offices. You are elected as judges in a state court. You don't deal with federal election laws in that. You're used to exercising in state matters, even state office elections, all kinds of discretions and opinions and options to manage your docket and your cases and basically exercise power. That is precisely why you are not judges. This has to be dragged out in the open because the conduct of the Gildea Court is a direct threat to democracy and free and fair federal elections. You decline. You have said These are judgments which are not allowed by 209.12 Congressional Election Statute. You can't pick and choose. You can't refuse. You can't apply res judicata. Certainly not from federal court precedents you pick out. And that is because this contest provision is something that happens in every single state in America. It includes the U.S. Constitution. It includes the laws passed and prescribed by the U.S. Congress, including the constitutional amendments which originated there and were ratified by the people of the United States. While you see one guy, one independent voter, who came in with a minor party ballot access, who is litigious and dissatisfied, I am showing you that you must see past that. You must see that if you continue to quash the democratic rights you are mandated to carry out under the CCEC, you will chip away not only at the vehicle of the independent voters of the state, not only small parties, non-Democrats, non-Republicans, non-lawyers, you undermine the very fundamentals, the foundation of America. Look in the mirror. That is not America. That is you, normally a very powerful judge, but in federal elections, a mere agency. Your hands are tied by the legislature. Your hands are tied by the Congress, and you are required to guard the liberties and rights of democratic elections. And you are required to carry out certain functions, just those certain functions mandated to you under Chapter 209. I have been forced to discover why you do what you do. I knew nothing of election law. I had to learn it. I found out from Clark versus Ritchie that the governors don't follow the state constitution, and you're all appointed, and that after she challenged, this is Clark, Joe Clark, challenged Gildea in an election, and in an election contest, she was suspended as a lawyer, because you felt she might be less than perfectly reasonable when she brought cases with third parties, clients, before you. And what I really meant there, she was not being reasonable. They thought that she had mental problems because she suggested she might not be treated fairly in cases before the Supreme Court. I learned Dayton and all the other governors work out a deal with every judge in the state, so they'll never be elected, only re-elected, always appointed. I learned then in 2012, because I never brought any case in 2010, even though I got the same third-party results I got in 2012. I learned that while federal courts can hear constitutional arguments about elections for Congress, that you, under the state election code, you're the only ones who can regulate elections, even federal elections, and enforce those regulations. Although your regulation and enforcement in legislative and congressional contests must respect the powers of those respective bodies as the sole judges of their elections. So I pursued infractions which had really hit me in 2012 in the last weeks of Betty McCollum's race, when I started to challenge the canard that it was Republicans who attacked the voting rights of non-whites, whatever. McCollum shouted out in debates that I want to fight for voting rights. So I brought up her party's voting rights practices, which violate the 19th Amendment, because they deny and abridge the voting rights of white males in all kinds of groups under their quota system. I brought up that they use racial quotas in violation of the 15th Amendment. This was a political rebuttal to her very public attacks on Republicans about voting rights. So she is allowed to say this in a congressional election, but I'm not allowed the same rights I've already been guaranteed by the Secretary of State. And none of this is denied on the record. If I counter her saying, no, you're not fighting for voting rights, that's something you say because your national party says so, but you're actually setting quotas for blacks and whites, women and men, homosexuals and those who disapprove of the lifestyle and pursue traditional marriage. As soon as this happened, Burt Black, OSS counsel, shows up and prevents me from receiving the email addresses I was told in 2010 and 2012 I could purchase and use for my campaign. Now this is getting rather longish, so I'm going to cut this second video and put this out there for you to see that yes, George, and I believe Steve Greenberg, I believe at the New York Times, this is proof, and this is not only here in Minnesota, it's happening definitely in California and Texas, and I'm quite sure many other states around the union, that we are spreading quotas, illegal quotas around the country to block the voting rights of white males and basically of everybody who doesn't get in that big, large minority group, which is women. Women are a minority. They're the majority minority. And Hillary Clinton is jamming this to the floor. They think that they are accomplishing some great thing of raising up women. What they're doing is tearing down democracy. I'm Steve Carlson. I approve this message. Thank you for listening. And please look for the sequel to this video. I will tell you much more about the action at the Minnesota Supreme Court.